court is going to come along and conclude, no, that's an unreasonable deposit and it won't be forfeited.
Hey everyone, it's Lawrence Mack from Remax Realtron here with Brian Madigan, Remax West. He's a real estate broker and lawyer. Hi Brian.
How are you doing?
I'm doing great today. Here to talk about deposits. Specifically, how much of a deposit as a percentage are we supposed to put in?
Generally speaking, the custom should be something in the range of about 5%. On the buy side, it should actually be as low as possible. Mm-hmm. On the sell side, it should probably be as high as possible. But there is an upper limit, and that is the limit is probably about 20%. And if a court saw a deposit in a transaction that exceeded that, the risk is that they would conclude that that was a penalty. Mm-hmm. And a court will not enforce a penalty in a contract between two parties. So the difficulty is that the court will not come along and lower the deposit to an amount that they feel would be appropriate. They will simply strike that out. So, for example, in a $1 million transaction, if we had a $1 million deposit, which sometimes arises with parties who are foreigners, who are transferring their assets into Canada, and they're not here yet, they will place all the funds in a property that they are proposing to purchase. Mm-hmm. So if we had a $1 million deposit in for a property that was worth $1 million, we actually fundamentally have a little bit of a problem. Problem being that the court is going to come along and conclude, no, that's an unreasonable deposit and it won't be forfeited. The amount probably that the court would look at would be $200,000, which would be 20% of the transaction. So in that particular case, what we really should have is a contractual agreement which provides that there is a receipt for the $1 million. 20% of it, or $200,000, is actually the deposit. And the balance of that amount, namely $800,000, is part payment of the purchase price. And that would be sufficient in the circumstances.
Yeah, I see. And the purpose, again, with actually having a deposit?
Well, one of the reasons in terms of having a deposit is to motivate for the amount to be sufficient to motivate the buyer to complete the transaction. So if the deposit is so small that one would easily walk away mm-hmm. without consequence, so we have a $1 million transaction, and what we've seen in some rural municipalities is it becomes commonplace to use a $1,000 deposit representing what they believe to be a sign of good faith. It's not really that, because it's very low. So we still have a $1 million transaction, and if a buyer had second thoughts about completing that transaction, what they're certainly going to do is give up the $1,000 and walk away from the transaction. They would have no hesitation. Court would look at that and say, well, no, we want the deposit to be large enough that the person is going to have second thoughts about it and feel that obligation to complete their transaction just like they said they would in their actual agreement of purchase and sale.
Well, so there you have it. So basically you're looking at roughly about the 5% range in terms of a deposit. And it's, again, to motivate the buyer to complete instead of just walking.
That's it.
All right. Well, if you have any questions, you can always give Brian Madigan a call, or if you need help with real estate expert witness testimony, he's your man. Talk to you soon. Bye.
Thank you.